Hello, good morning, everyone. I will be discussing proposed legislation and amendments to laws to strengthen the legislative framework towards durable solutions for refugees, stateless persons, and other persons of concern. Next slide, please. First, let's look at the international framework on which these proposed measures are anchored upon. Foremost among these international agreements to which the Philippines is a party to are the 1951 Refugee Convention and its 1967 Protocol and the 1954 Stateless Convention. These conventions both contain an article on facilitated naturalization, which states that parties to the convention shall endeavor to facilitate the naturalization of refugees and stateless persons, and also make every effort to expedite naturalization proceedings and reduce the charges and costs of such proceedings. Other relevant international framework include the Global Refugee Forum and high-level segment on statelessness and international treaties and conventions such as the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Convention on the Protection of the Rights of All Migrant Workers and Members of their Families, the Convention on the Rights of the Child, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention on the Rights of Persons with Disabilities, and the Convention on the Elimination of All Forms of Racial Discrimination. Next slide, please. In order to comply with these international covenants, the following frameworks were formulated. First, the Philippine Development Plan of 2017 to 2022, wherein there is a chapter which enhances the legislative framework for persons of concern. Next, the Interagency Steering Agreement on the Protection of Persons of Concern, which improves the access to rights and create a favorable protective environment for persons of concern. And third, the National Action Plan to End Statelessness by 2024, wherein there is action point number 4, which aims to grant protection status and facilitate the naturalization of refugees and stateless persons. Next slide, please. Now, why naturalization? Earlier, there was a question posted regarding. I think the question was framed as why would a refugee would want to be naturalized instead of staying as a refugee? And our speaker already mentioned that it is really hard for refugees to have access to basic rights such as access to education and work and other things needed to survive. So we see naturalization as a pathway towards durable solutions and local integration. For stateless persons, it is actually the only durable solution. And it is naturalization is also provided under the Constitution and currently governed by 2 laws, Commonwealth Act 473 and Republic Act 9139. Next slide, please. With the current laws on naturalization, we observe several gaps and challenges for those applying for citizenship through this process, especially if the applicant is a refugee or stateless person. First are the rigid qualifications and disqualifications, such as residency requirement. RA 9139 requires residency since birth, while CA 473 requires continuous residency of not less than 10 years. There is also a need to harmonize both measures with contemporary laws. For example, one of the disqualifications is mental alienation, which is a form of discrimination according to the Department of Health. In line with RA 11036 or the Mental Health Act, it would be more appropriate to use the term mental illness. In the proposed facilitated naturalization bill, mental illness is also qualified by the condition of having active symptoms resulting in temporary impairment and decision-making capacity. It is worthy to note the case of Mr. Carbasi, wherein which only demonstrates how lengthy the process is, because it took him 17 years before he became a naturalized citizen of the Philippines. Also, as mentioned by our Chief State Counsel earlier, it is in this case of Mr. Carbasi, wherein the Supreme Court elucidated on the qualification of on the requirement of capability to support themselves. So it is not to be strictly construed. The Supreme Court even quoted the Court of Appeals decision wherein Carbasi went from being a refugee who was dependent on the UNHCR for support to being a self-made entrepreneur who can ably support himself and his family. As such, there was no showing that Mr. Carbasi may turn out to be a public charge and a burden to our country's resources. The fact, moreover, that he overcame this adversity through his education and skills shows that he is a potential asset of the country. Next slide, please. Here we see the development of the Facilitated Administrative Naturalization Bill, pursuant to Action Point 4 of the National Action Plan to End Statelessness, and the different agencies involved in its development. It is also worthy to note that aside from agencies under the Executive Department, the judicial branch is also active in the development of this bill. Next slide, please. Here we have the salient features of the Facilitated Administrative Naturalization Bill. First, it expedited the procedure for recognized refugees and stateless persons, and the fees were reduced, and in some cases, the fees may also be waived. It is aligned with contemporary laws and frameworks as considerations for persons with disabilities were made. Unaccompanied children, in line with their best interests, can also apply for naturalization, and it also reduced the requirement for habitual residence to a minimum of 3 years from recognition as a refugee or stateless person. Proficiency in language is not required, so it would be sufficient for the petitioner to be able to communicate. The spouses may also file for a joint petition, and there is also derivative naturalization for children, and remedies were also provided for, such as a motion for reconsideration and appeal. The Special Committee on Naturalization Secretariat was also institutionalized. Next slide, please. We now go to the gender-responsive amendments to naturalization laws. Revise. Here we have the some of the provisions in the current naturalization laws, which we view as not gender responsive. Under CA 473, on the effect of naturalization on the wife and children, any woman who is now or may hereafter be married to a citizen of the Philippines and who might herself be lawfully naturalized shall be deemed a citizen of the Philippines. And in RA 9139, on the status of alien husband and minor children, if the applicant is a married woman, the approval of her petition for administrative naturalization will not benefit her alien husband, but her minor children may file a petition for cancellation of their alien certificates of registration with the Bureau of Immigration, subject to the payment of the fees prescribed in Section 17 hereof. Next slide, please. We see these provisions as antiquated and discriminatory on the basis of sex, since women are unable to confer their citizenship to their husband, and the wording is also not gender sensitive. There are also no adequate safeguards in place to prevent statelessness in reference to the 1961 Convention on the Reduction of Statelessness. Next slide, please. The legal frameworks in proposing these gender-sensitive amendments are the Constitution, the Magna Carta for Women, which reads, "Women shall have equal rights with men to acquire, change, or retain their nationality." The state shall ensure in particular that neither marriage to an alien nor change of nationality by the husband during marriage shall automatically change the nationality of the wife, render her stateless, or force upon her the nationality of the husband. Various statutes of other countries concerning dual citizenship that may be enjoyed equally by women and men shall likewise be considered. Next slide, please. Another is the Convention on the Elimination of All Forms of Discrimination Against Women, and Article 15 of the Universal Declaration of Human Rights, which provides that no one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. Next slide, please. The proposed amendments are also in line with action point number 3 of the National Action Plan to End Statelessness, which aims to remove gender discrimination from nationality laws. And you also see here the different member agencies involved in this action point number 3. Next slide, please. Some of the features of these amendments are the use of gender-neutral language, the alignment of the qualifications with contemporary laws such as the Magna Carta of Women, Mental Health Act, and the Filipino Sign Language Act. Safeguards were also incorporated to prevent statelessness, such as in the provisions where the naturalization certificate would be cancelled. The loss of the citizenship for the naturalized person shall be conditional upon the possession or acquisition of another citizenship. This is in reference to the 1961 Convention on the Reduction of Statelessness. Next slide, please. Action point number 6 of the National Action Plan to End Statelessness is the accession to the Statelessness Conventions. A TWG was formed towards this end, composed of various government agencies from the 3 branches of government. Next slide, please. Here we have an overview of the accession process. It starts with the ratification by the President, review of treaty vis-a-vis national laws and policies, submission of certificate of concurrence to the DFA, and then the DFA prepares the instrument of accession, and then the President ratifies the treaty. Then for the Senate concurrence, it is referred to the Senate Committee on Foreign Relations to conduct deliberations. It must be concurred in by 2/3 of the Senate, and the COC is transmitted to the DFA for the appropriate deposit, registration, or notification necessary for the entry into force of the agreement. Next slide, please. Here we have the salient features of the 1961 Convention. It grants nationality to children who would otherwise be stateless. Provisions which would prevent statelessness by requiring prior possession of nationality. As to articles concerning deprivation of nationality, there is non-discrimination within the context of such deprivation. There is also a requirement to respect due process, and it only allows for deprivation of nationality in certain limited cases, such as misrepresentation or fraud. The Convention also ensures the prevention of statelessness in treaties dealing with the transfer of territory. Next slide, please. A population considered at risk of statelessness are foundlings. The cause of statelessness risk for foundlings is the inability to register their birth certificate due to difficulties in establishing parentage. Based on Supreme Court rulings, foundlings as a class are presumed to be natural-born citizens. Now, in order to reduce this risk of statelessness, a two-pronged strategy has been adopted. For the administrative track, it is for the issuance of birth certificates for foundlings, and then for the legislative track, it is the passage of bills into law. Next slide, please. These foundling bills are based on action point number 2 of the National Action Plan to End Statelessness. which aims to ensure that no child is born stateless. As previously mentioned, currently there are pending bills such as Senate Bill 2233 and House Bill 7679. Next slide, please. The relevant framework for the founding bills are the Philippine Development Plan of 2017 to 2022, the action point number 2 previously mentioned, and other Supreme Court rulings. The scope of the bills include foundlings, including aged-out foundlings. The Senate version even covers foundlings who may be found in Philippine embassies and consulates. The bills also address the risk of statelessness. By virtue of the recognition as a natural Filipino in line with Supreme Court rulings through birth registration. In the Senate version, foundling shall not be considered stateless from the period of finding and issuance of confirmation of citizenship. It has provisions on protection such as access to programs and services for registration, facilitation of documents for adoption, education, legal and police protection, proper nourishment and medical care for survival and development, and admission to safe and secure child centers. It also has provisions on search and inquiry, wherein facts of birth and parentage of the foundling are inquired into. Next slide, please. It also has provisions on safeguards, such as the revocation of the birth certificate if there is a finding of fraud or the parentage of the foundling is established. It is also unique for having the safe haven provision, wherein the relinquishing of an infant 30 days old and younger would not be a criminal act under the revised penal code. Advocacy and information dissemination. It has advocacy and information dissemination provisions concerning foundlings, and data collection provisions wherein the LGU coordinates with the Philippine Statistics Authority as guided by the Data Privacy Act. And for age-out foundlings, the foundling shall undergo the procedure and comply with the requirements in the transitory provisions on retroactive application. Thank you. That would be all.